All right. Hi, this is Curt,
And Brad Pinsky.
and we are here for another edition of Fire Law Roundup for December 2nd of 2024. And Brad is here with a completely white background.
I am in my temporary holding space for the moment. So I'm in a construction
You're not
zone.
in prison.
No, no, not yet anyway. So,
All right, well,
um,
let's go.
yeah, let's start in the UK because there's not enough going around in the United States. Who knows?
Well, I just so you know, I cover the UK and
Yes,
Australia. If I could
Canada.
interpret a lot of the other foreign language newspapers and things, then I'd cover them as well because the stuff is universal. The stuff that happens it's not unique to us, and I think that's important for folks to realize.
It
We
is.
we beat ourselves up quite a bit on this, but it's beyond just us. So.
No, it's a worldwide culture of the fire service, frankly, and some of this, and maybe it's male driven, maybe it's employee driven for those toxic employees, right? But there's nothing that unique to what happens in United States fire departments, as we've seen from your coverage of not just UK but Canada with discrimination claims and just a persistent presence of hatred and bullying and harassment.
or
It's not the
or
U.S.
allegations of the same,
Exactly,
which
whether
may or
true
may
or
not
not,
be true.
right? So in the UK, here's what we have going. We have a female employee. She was with the West Yorkshire Fire and Rescue Services, and she accused a manager of being a sexual predator. Um,
That's
and
pretty
this comes from
that's a pretty serious allegation.
yeah, well, that's a criminal allegation as far as I'm concerned, at least in the States.
Yeah.
So if you stop there, you'd be like, oh, this is horrible. But then you read further, and again, the court disposed of this, right? Got rid of it. But the allegation, which I guess the court credited, is, even if true, what does it matter? The court says, but he comments on her handbag. Um, and so I'll get into why, but effectively it was a comment on a handbag. So here's what happens. So she was an employee. She was using her sick time. She used the sick time or sick leave, she claimed, based on stress. And she was called in for a meeting with, I assume, HR or corporate services. And he commented, maybe to make light of the situation, maybe not. He commented on her designer handbag and said that he had purchased handbags there for his wife. And although they had recently split up and he was lonely. Now, I don't know why, assuming even if that's true, why somebody would say that with the handbag stuff. It seems a little weird. Nonetheless, she then claims that the meeting turned into a sexualized freak show, to use her words, not mine, and referred to the individual who made the handbag comment as a sexual predator. She resigns and sues, and a court found that there was no valid claim except for one called victimization, which I think you properly say is retaliation.
Yeah.
And the victimization occurs in the UK when someone is subject to a detrimental conduct because they either did or believed to have something that's protected. In this case, such as making a complaint. But that's very much like the retaliation whistleblower stuff, anti-retaliation in the States. So the court concludes that after she complained about sexual harassment, she was threatened with a pay stoppage for failure to submit medical documentation about her absence, justifying her sick leave, which certainly, even in the States, is a very valid request. You
You
can't
would
just say
think.
you're sick, right?
Yeah.
So in any event, the judge then concludes that even though the comments were probably unwise, it wasn't sexual harassment. It was a clumsy attempt to gain her confidence, but it was not conduct related to sex or of a sexual nature. I don't know that I totally agree saying he's lonely, but maybe saying you're lonely doesn't cross the line. It's not, I'm lonely and come over to my house tonight. It's, I've just been lonely since my wife and I split. Now, I don't know why someone would say that, but there you go.
It opens an unfortunate door, and I'm sure this was not a recorded interview, which, I'm a big fan of recorded interviews
Yes.
when you're dealing particularly with difficult employees,
Yep.
because if they say you said it, of course, you're going to say you didn't say it, and then they're going to say, well, why would they say you said it if, and you're just better off having it recorded.
Right.
But
Right. And I think if you tell someone it's recorded, they are less likely to put something out there that's false because
right,
they know you have the truth, and that may prevent everything if you didn't say something you shouldn't have said.
right. And if you did say something that you shouldn't have said, then you're going to pay the price.
Right. So I think the tip here is interviews, and I'm sure one of the policies we'll be doing on must-have policies will be interviews, interview techniques, things like that, investigative
I
techniques.
have that policy all set to go when we get to that point, but that's all set to go. But again, folks who've been through my discipline class know that I'm a big advocate of recorded interviews, and this is not to disadvantage the person being interviewed. On the contrary, it's to keep everybody honest. It's not to disadvantage the person being interviewed. It's to make sure that the interviewers get it right, and that the interviewers aren't necessarily accused of doing things wrong. And one of the things I've seen in my practice is that very often unions don't want recorded interviews because they think it's going to trap their people, and the city attorneys don't want it recorded because they're afraid the investigators are going to say something inappropriate, or and they want to have the wiggle room, right? So that alone should tell you it's probably a good idea that we record. It's kind of like if you go back to the 1950s and say we want to record, we want to put body cams on police officers, people back then say, oh, that's crazy, but in
And now the
hindsight,
cops love them.
so, and I think we're there when it comes to these types of interviews as well. But
Absolutely.
I will get off my stump.
No, I think that's a big point for people to pull aside. I think the problem will be, because I support you 100%. You're right. Record it all and don't say something stupid. But if you did, and because I've trapped people when I depose them or at trial, I'll be like, is this what you said? And they're like, well, not exactly. I'm like, so it was close, just not exactly. And they're like, no, that's not what I meant. I'm like, was it said or was it not? Well, not like just play the recording. It would have been so much easier. Okay. In any event, let's go to Florida. I'm having a hard time not making condescending comments, but I just want to be upfront that because of the way things were pled, I'm having a hard time not being critical, but that's what we get to do. We get to be critical. So we have a firefighter who was suffering allegedly from a undisclosed health condition. She never says what it is, which is the problem, or he never says what it is. And he claims he was wrongfully terminated and discriminated against, of course. And yes, you get termination, discrimination. What else do you get? Retaliation. So he gets a retaliation claim as well, always comes around. And he said that that as a result, the Marion County Fire Rescue violated his rights under state and federal laws, disability laws. And the problem is, I'll go through it, but they never disclose the type of disability. And you have to do that. You can't just say, I had a disability. For example, there are comments made in
right?
here.
You have to plead facts, and that's a conclusion.
Right.
And so you could argue it's a pleading issue, but and I'm sure he did that because he didn't want to disclose exactly what the nature of the disability was.
And again, for the viewers, we'll go through this in a second, but there's allegedly comments made about someone's weight, and weight is not a disability under the ADA, except in some rare circumstances. But simply being overweight as a primary condition, not as a result of another disabling condition, like maybe diabetes or something, is not a disability. So it's important to claim, right, what it is. And frankly, I'd be moving to dismiss, saying, you haven't met your burden. You got
on its face. It fails to state a claim.
Yeah. But here's what's happened generally. So the employee says, I was suffering from a health condition. It began to impact my work. It created a challenge to my job duties. And so in 23, they're kind of he's relaying what's going on. And allegedly he said, there's a physical it's a physical related disability, but something to do with your weight. they tried to allegedly, instead of accommodating it, he says, instead of accommodating, you disciplined me, right? Which is kind of true, but they came out with a performance improvement plan, which I'm not sure is discipline, by the way.
I mean, we talk about that in my discipline class also. The line between like excuse me, counseling and performance improvement and discipline is up to the employer. And in one fire department, something like counseling could be discipline. In another fire department, it may not be. It depends on how you define it. And if you don't define it, guess what? It's going to be up to a judge or an arbitrator to define it for you. So you're better off defining it.
Agreed. And look, a PIP or counseling really shouldn't, in my personal opinion, shouldn't be discipline.
I agree.
It's to make you look. What's the point of discipline? To make you better, to correct the problem so it doesn't happen again, to improve you, to make you a good employee. So an improvement plan, is not a bad thing. Right. It's when you put in words like, if you do this again, you'll be terminated, that becomes the problem in some of these. But in any event, there was a PIP issued, and then it allegedly had to be reissued, and it was then extended because it allegedly wasn't done properly. And meanwhile, the employee saying, I'm having additional health issues that's triggered while performing my duties. Even I think says this is all as a result of my job, frankly, which again, what's the disability? But he then he was required to provide documentation that showed his medical clearance for duty, and he was given 45 days to do it. And there's nothing inappropriate about an employer saying, you need to show me you're fit for duty. And they did it with his doctor, I think. And he couldn't get it. Now he says, I couldn't get it by the date, right? I had a death in my family, so I couldn't go to a meeting about it. And so as a result, I get terminated. The problem is, you're given 45 days to get a letter from your physician. That really shouldn't be that tough if you're seeing a physician. In any event, it goes to the point she gets terminated for not showing up for a meeting because she allegedly had a death in the family. And he's just saying, look, you terminated me for a disability. But again, if you don't have the facts, then you don't have the law, right? And here, there's just no proof of what that disability or condition was. And if it's weight, it's likely not even a disability. And so if you can't say that you have a disability, how do you even make your ADA claim out?
Yeah, and this is, again, shows the sort of crossover between the FMLA and the ADA and how they can create problems for us, because the FMLA allows you the employer to do certain things in terms of medical documentation. The ADA has an entirely different set of requirements. Okay.
Right.
So the question becomes, how do you comply with the FMLA? How do you comply with the ADA in terms of what you can ask for, what you can do with that information, and so on?
Who you can ask it from, right? FMLA is you go to your doctor. ADA, right, on at least the essential job performance, maybe you can go to the workplace doctor to say you're qualified or not. So it matters, as you're pointing out.
Right, exactly. And then you throw in the joker in the deck, which is workers' compensation law, which allows right. No, seriously, but
this is where you get IMEs,
the challenge for those firefighters out there who have never worked in the front office of a fire department. This is the crap that just makes you say, I wish I was riding backwards again. Right. Drives you crazy.
As you're out joking and playing and drilling and doing all the other stuff, your superiors are dealing with this, right? Unfortunately. Okay, this is probably one of the most interesting cases of the year. As we get to the end of the year, this will definitely be on my list. We're going to go to Michigan, and this is really interesting. The facts are pretty interesting to start, but we have two kind of issues here. So we have a female who's the first female firefighter in this department. All right, a big deal. And of course, you know what's going to come when you hear that, right? You're going to hear the women don't belong in the fire service and all the other derogatory, inappropriate comments that are going to come with it. But the start of the claim is one of the most interesting things I've seen in a very long time, which is she claims there was no facilities for her, right? And it makes sense. It's been a male-dominated firehouse until her. They don't have individualized bunk rooms. It's a shared bunk room. It's a shared shower, shared bathroom. There are no facilities for women, which begs the question, and I'm going to give an answer, which I don't know that I even agree with my own answer, but it begs the question. So now you've hired somebody, you don't have the facilities. What is your obligation? Right. What's your obligation now to them? You have to hire them.
Let me throw something out there. What is more important, words or actions?
Actions.
Actions, obvious. Okay. Now the firefighters they say words. Women don't belong in the fire service. What happens when a municipality doesn't properly fund a fire department, requires them or allows them, or whatever you want to say, allows them to hire women, and then doesn't provide the monetary support to retrofit the firehouses to accommodate the women that got hired? Is that an action or word?
Right.
So you got the firefighters there say words, and by actions, the municipality is doing nothing to accommodate a woman in the workplace.
And the men's words, there's parts of this that went way further, but the men's words reflect their employers' lack of action.
I got to tell you, with this one, as I read the complaint, like a lot of complaints I read it, I go, yeah. Okay, another female firefighter alleging whatever, right? I read the first one. I read the second one. I read the third one. And then the fourth one. And then the fifth one. And then the sixth one. And it just went on and on and on and on. And
she has a lot of very specific allegations. And so let me throw this out to people, right, to our viewers here. So we've got somebody allegedly urinated on her or talked about urinating on her, people making inappropriate comments like women don't belong here.
Bed. I think it was on her bed, not on her.
Oh, on her bed. It says while she was sleeping. So I'm not quite sure.
Geez. I might have missed that as I was reading.
Yeah, I think it said while she was sleeping. But in any event, it was either on her bed and the rumor was videotaped, although that hasn't shown up. There's a lot of porn in the firehouse. There's group showers together, not as an inappropriate thing, just that's men are showering, group bathrooms, right? Inappropriate sleeping quarters, men sleeping as they do in just underwear or shirt or whatever. Nothing shocking, but for add a female in the mix and it becomes not good. Right. Now here's the normal firehouse stuff, the abnormal firehouse stuff that goes way, way, way beyond. Right. Of course, you get a fellow firefighter placing a mannequin or two mannequins if they're performing sex acts. Is that directed at her or not? Who knows? Right. And then if this is true, it just reflects a bad culture. A lieutenant allegedly takes his shift, the B shift, including a probationary member, to the strip club. And then there is a video of one of the probationary firefighters performing a sex act. Personally, if that's true, having nothing to do with her, the lieutenant should be disciplined. You don't take your probationary firefighters out to strip clubs. I get the culture, but it's not appropriate for a superior to do that. It's still harassment. That's going to, anyway, bad idea. The firefighter, she said she's trying to do everything she can to fit in. Sorry for the banging in back, if you can hear it. So she said she's trying to do everything she can to fit in. She's complained within the chain of command. But then there's a chief. This is really, it keeps getting worse and worse and worse. A chief allegedly walks up to her, walks behind her, pulls her ponytail, pulls her head back, pulls her body into his. She pulls away, demanded he stopped. He walks away. Allegedly. I doubt there are cameras there, but who knows? And that's where it goes. She's been called names that I don't know if I can say on YouTube. And she allegedly has done what she did to report it. And here you go. And look, if that's true about the chief, we're not saying it is, we don't know. If that's true about the chief, that culture flows downhill, right? And as you said, even above him, because it's the facilities aren't there and the municipality doesn't seem to care.
It's kind of hypocritical that a department would criticize some of the firefighter activities when their own actions by not properly funding the retrofit of the stations.
Right.
And you know, I lived through this in my career in departments where they just you're getting lip service that we're gonna be inclusive, okay? But by the way, you're not going to get any more money, and we're not going to retrofit the firehouses. And then you have a station, you know, some of our stations in Providence are pretty big. We have 8, 10, 12 people there, and one of them is a female, and you come back from a fire. So who's going to go to the, you know, who's going to get the shower? Who's going to do that first? And she's going to sit there and wait till 12 people, 10 people are done using the bathroom. Then she can go in, or she can lock them all out.
Right. So I'm trying to think how to analyze this. If you looked at it like, let me give you the juxtaposed positions. If you look at it like an ADA claim, there's no obligation to rehab your facilities unless you're doing renovations and things like that. But just because someone disabled or impaired shows up, you don't have to just, redo your facility. So on that line of thinking, they wouldn't have to do anything to her. But on the other hand, there's gender identity cases. Yeah. One comes to mind where it was the exact same situation, and the person didn't want, it was, I think, a trans man, someone born female, identified as a male, but didn't want to make anyone feel uncomfortable. So the individual was allowed to use the captain's office right down the hall, 20, 30, 40 feet down the hall. And they tried to accommodate. The captain said, listen, just knock on the door, come in, you can change, you can do whatever you need. We'll get a bathroom set for you. There's one way down the other end. And the court says that's discriminatory. You have to have the facilities for somebody. But there was different. They had male or female facilities. They could have used either one. They didn't want to, but they could have made easily accessible changes to the firehouse. Here, I don't know whether that's true or not. So I haven't researched it. I don't know which side this falls on. No obligation to make your facilities right. And I would tell you this. I would argue, if I was her, this is what I would have argued. I would have argued that the municipality's refusal to bring the bathrooms up to code were an intentional choice to prevent women from wanting to be employed there so that you didn't have the facilities. That's what I would argue. I'd take that whole thing out of, right? The whole, did they have to or not, out of there, and just say they chose not to. It's, 8% of our fire service, although too low, is women. And it's not like you weren't going to have a woman score the highest on an exam or be hired, and you made it impossible for them to succeed at your fire department. You made a choice, and that choice not to rehab your facilities is the discriminatory act. I would have led with that.
Whether that is a legal requirement, we can debate. But in terms of a leadership, from a municipal leadership perspective, it's hypocritical to say that we're going to be inclusive. Yeah, but we can't afford to even put a lock on the bathroom. It takes 6 months to a year to put even a lock on the bathroom. I mean, give me a break.
Right. And look, just to make some enemies.
It's either important or it's not. And if it's not, don't pretend it is.
Right. Right. Just fess up. You don't want women and pay the price.
And that's the municipal. But then when the municipality says that, and of course, no municipality is going to overtly say that, but when they do it through their actions, don't be surprised when the firefighters say the same thing. They just verbalize it.
Right. And I got to tell you, I'm so tired of this male-female issue on the male side. I'm so tired of hearing women don't belong in the fire service. Right. And often that comment is made by 400-pound, overage, physically, incapable men, right? I mean, some people would rather have a fat, overweight, weak, incompetent male than a female who can run a triathlon. And you just make those stupid comments without any basis in reality. And I hate to say it, but when I lecture, I say that all the time. I said, those of you who don't believe that women should be in the fire service, why don't you look to your right or your left as to who is actually in the fire service? They're not in the best shape. So why don't we talk about physical characteristics, strength characteristics, endurance characteristics having nothing to do with sex or gender?
Well, we study this a lot in the forensic psychology program I'm in, and it's implicit bias or confirmation bias that's at work. And I'm sympathetic to a certain extent on the folks that think that, but they've got to realize that they've got a bias, and it's blinding them to the reality, so that when they see a weak man, they look past it, and they see a female, and they, for whatever reason, they just can't look past it. They just can't.
And if you just
and
change,
we've got to bring that to their attention.
Right. And I hate to say it, if any of this is true, right? We're not condemning the department. We don't know any of it's true. It's an allegation. But if any of it's true, the problem starts at the top. At least our top was the chief. The chief could say, listen, we got to do something here to change our ways. And maybe there should be sensitivity training. And, or maybe we should call all their mothers and have them come in and teach them how to act. I don't know what it is. Sue me is one thing.
You
Call
guys
my
don't
mother.
clean up your act, I'm going to have your mothers come in here, grab you by the
way
ear.
scarier than a lawsuit.
You won't
Okay.
say that.
Let's I think we're finishing up number 4. Let's go to California, from Florida to California, all the way across. We have an appeals court who has upheld a trial court. And the trial court ruled that the city of Paloma here, and 2 of its firefighter-paramedics cannot be held liable for medical injuries of a patient who repeatedly declined medical care. So let me stop here, because I don't know if you know, but I don't know. Let me start with what I do know. In New York and many other states, so our viewers understand, there's something called a special duty. Now, to prove negligence, and you got to understand this, and we always use the term, oh, they were negligent. Well, negligence, not really anything. There's 4 components to an injury, an unintentional injury causation lawsuit, which we call negligence suits, right? And normally it's, I owed you a duty to act. And the second is, I breached my duty. The third is that the breach of my duty caused you injury. And the fourth is you had an injury. Municipalities often get a protection that says we owe a duty to the general public. We don't owe a duty to any one person. So when fire departments arrive on a scene and nobody's yelling at them, right? But they're like, okay, we're going to go in, we're going to knock it. They don't owe a duty to anyone specifically in the building. Now, somebody comes out on the ledge and says, help me. And I say, okay, stand right there. I am coming for you. Now I've taken the steps to create what's called a special duty. And a special duty, again, is I didn't have a duty like normally, like any person would have toward another to be careful or whatever. But maybe I had a special duty because I had one-on-one contact with you and you relied on me. Why do I bring that up? Here's the facts. And then I want to tell you what the court said. So the facts, fairly simply, or somebody gets into a head-on collision, the paramedics come, they're trying to evaluate, they keep telling the patient, you could have some real serious injuries. They rule that she's alert and oriented or competent and has the capacity to refuse care. So it's a valid refusal, but she keeps refusing care, and they keep urging, she keeps refusing. They keep urging, the patient keeps refusing. Patient signs off. What are they going to do? They can't kidnap the patient, right? And take them against their will if they're alert oriented, if they're competent, if they have the capacity to refuse. So what do? Well, she signs off. Next day, catastrophic injuries, right? So, and she sues, not arguing, not debating that she constantly refused care, but that their refusal to treat her was a breach of duty. And the court says, wait a minute, breach of duty is the second step. First, I have to prove you have a duty. And the problem I have is, oh, and by the way, why do they care? Because breach of duty is a question of fact, and that goes to a jury, which costs a lot of money, where people may pay a little money, insurance companies may pay up. But a duty issue is a matter of law. A judge can rule on that in the first instance without a jury, get rid of this immediately. And what the court does is use a phrase I'm not familiar with, but I wonder if you are, and I wonder if it is the special duty, right? Because the court holds that there was no duty owed to the patient. There's no duty of care owed to the patient. And they use a term of art, which was called, let's see, where is it? Sorry, I am missing it. Never had an opportunity. I'll find it. Well, are you seeing it? They use a phrase that I was never seen before. It's a doctrine of There we go. Negligent undertaking. Under the negligent undertaking doctrine, they say there's no duty of care, but I couldn't really understand the negligent undertaking doctrine. If I would to guess from the name, I would assume it says you only have a duty if you undertook to help the person, right, in a way that creates a duty. But here they did have a duty.
I think, this is where, the judge has apparently some discretion, and apparently the appellate court continued that discretion, is when I fail to stop at a red light, is that a failure to do something, or is it doing something negligently? Okay. You think about it, you could argue it either way. It's the failure to stop, so it's the failure to do something,
right? Or you
but at the same time, it's right. So, and here, did I negligently assess the patient, or did I just fail to assess the patient? Because if I just failed to assess the patient, I didn't have a duty to assess. So, so I think it's a little sleight of hand, a judicial sleight of hand. In that regard, but
look, if
my
you show
take
up
on this,
if you show up and you put hands on someone, you owe them a duty. You may not.
Well,
when a volunteer
I think
firefighter,
that's, from the judge's perspective, maybe it was what the attorneys argued, but it looks like from the judge's perspective is that the person said, "I'm fine. Don't touch me. I don't want you to take my blood pressure." Because I think one of the issues was this at the heart of this was she had a stroke the following day. And she was hypertensive. And there's a question about whether or not, if the medics had taken her blood pressure and realized she was hypertensive, that she might have gone in for treatment and not had the stroke. Or maybe, I don't know if it was the next day or 2 hours later, but a certain period of time after the accident, she had a hypertensive related stroke. So, I think that is, I don't know. My read on this, though, goes in a different direction, and it's really a function of some of the training that I've sat through, and the instructors emphasizing how important or sign refusal. You got to get a sign refusal. You got to get a sign, like it's the end all. And honestly, from my analysis of the cases that I've read and looking at these, like really studying these cases, you cannot make a bad medical decision and then expect a release, a written signed release to absolve you of liability if you make a bad medical decision. Okay. And at the heart of this is not a bad medical decision. Okay. She had no symptoms. She had no complaint. Okay. Some people would even argue she's not even a patient, because a patient has to have a complaint. That's what separates a patient from a subject or a bystander. Okay, that they have a complaint. Again, it's about the medical decision, and I think stepping back, taking the 50,000-foot view here, the firefighters made a good medical decision. They did not make a deficient medical decision. When someone says, "I don't want you to take my blood pressure," how can you take their blood pressure? It's a good medical decision. Okay, now if they were the ones that looked at her and said, "Okay, you're fine, you don't need to," that's a bad medical decision. But they made a good medical decision. And so however the judge sort of intellectually breaks all this down and finds them not liable, I think the court and the judges involved made the right decision. But what we can't delude ourselves is by making a bad medical decision, change the facts,
and cover it up in writing.
And try to cover it up in writing. That is not going to work. And yet we have well-intentioned instructors out there saying, "You've got to get a refusal. You got to get a refusal." No, you've got to make a good medical decision. And if you make a good medical decision, it doesn't matter. You should get absolutely, positively get or sign refusal. Absolutely. But make a good medical decision.
And I'll tell you, the signed refusal, you better, and maybe we'll do this as one of our upcoming policies for the EMS side, but the signed refusal better say what you refused. If you just said, "I refused care and transportation,"
and the information you provided.
But think about it. If I just say I refused care, well, wait a minute. Is that evaluation?
Right.
Or is that just treatment for a bloody head? right? And if transportation is a different thing, I refuse transportation. I have done refusals on people that I've transported who say, I don't want an IV. Okay, fine.
Yeah.
Right? You refused the IV. Write that down. Why didn't we do it? You refused it. We still transported you. So here, I hope, not that it mattered, but I hope that the refusal says you refused evaluation. You refused to let me perform blood pressure and blah, blah, blah. And, you know, we advised you. And if everyone's worrying what should be in a refusal, I'll put this one point. You should not be telling people, oh, in 3 days you could develop this and then you'll have, or maybe you have this condition. You can't do that. You can't diagnose a condition. As an EMT or paramedic, you don't diagnose. But what you can say is, look, you could become more sick, more injured, or dead, right? More sick, more injured, or dead is my standard line. That is clearly allowing you to assume and evaluate the risks. When I tell you you could become more sick, more injured, or die if you refuse care and don't let us transport you, now, as far as I'm concerned, that's on you. But did I have a duty still? I did. So I don't know that I agree on the duty thing, but maybe it's a California specific type rule. I just didn't understand.
I think the judge, they reached the right result intellectually. And I think a lot of times we were actually studying this in judicial decision making in the class I'm in right now. And the judge reaches a factual or emotional point where they rule in a certain way and then they backfill the reasoning.
Exactly.
So,
and I believe this is what happened here because they all agree, listen, this is a bad case, right? There's no questions really as to the fact. They did warn you. They did tell you to go. What more are they supposed to do? And you want to hold the paramedics and the fire department in the city accountable for your refusal to listen to them. Yeah. So I do. I think that, right. Anyway, that's our cases.
All right. We only had 4 this week, so it was a short holiday week. So that's going to do it for another edition of Fire Law Roundup. If you haven't already done so, please subscribe, please click like, please share, and please comment. We have been getting some comments, but certainly we welcome the opportunity. And if you have any thoughts, maybe some directions you want to see us going with some of the cases or other things, please feel free to add that in as well. All right.
And please make sure to check out musthavepolicies.com.
Absolutely. And that's going to do it for another edition of Fire Law Roundup.